slides. So hopefully, Chris.
That's just coming up now.
There we go. Is that all coming through, Chris?
Fire away, Tim.
Thank you very much. Thanks for the interaction, Chris. I'm Tim Thomas. I'm with my colleague Alice Tranter. We're from the IMC Consultancy. We help make UK members with international mobility issues when they've got workers travelling from either the UK to the EU or vice versa. Just by word of background, we both worked for Make UK for a substantial period of time. We also worked with Fergus over in Brussels. So this is something that we've been assisting Make UK with, both as internal staff and as consultants for a significant period of time. We're going to look at all issues surrounding travel from the UK to the EU for workers, as you said, Chris, with things opening up, becoming more of an issue for MIC UK members. Look at some of the main pitfalls, some of the things you need to be cognizant of when you're sending or receiving workers. And also then we'll look at some polling questions at the end to get your feedback, to find out how well versed you are in these rules and whether you need any more assistance from MIC UK. So we're going to start and delve straight in with some key changes since the UK's exit from the European Union. Brexit means that we've left the European Union. We've also left the single market and the customs union. So all those institutions that we were used to trading in, dealing with before, well, we're now outside of those. We have what's called third country status. So we've lost access to provide services within the context of the single market. And whilst we might like to think of services as financial services or accounting services or legal services, in the context of what we're talking about today, the movement of people whilst a member of the EU, always fitted in with the services element of the single market. So that means now we left the single market and now we left the services part of the single market. All the EU rules that made it easy for us to go to the EU and work, they've all fallen away. So we're now within a new legal framework. Now that new legal framework is the new Trading Cooperation Agreement that was negotiated between the UK and the EU. And the Trading Cooperation Agreement covers not just trading goods, but also the trading services, therefore the movement of people, and also some interesting rules on social security coordination that we'll cover off later. That will be very important for employers if you are sending your UK workers to the EU. Now, these new rules impact on all UK businesses who have European clients. They'll impact on all UK businesses that sell into the EU, that might trade in goods, but also provide services. So you may be commissioning, installing, maintaining, providing warranty on goods that you're selling into the EU. So these rules are quite all-embracing, and they might be a little less known than the trading goods rules, but they're no less important. So all types of business travel, whether you're visiting as a business visitor, whether you're sending colleagues there to work, whether they're servicing, whether they're intra-corporate transferees, if you're part of a wider corporate group, perhaps, and you've got sites in the EU. These are all now going to be subject to new rules, which, as we'll see in a moment, substantially are going to depend on the rules of each EU member state. So the trade agreement and what it means that different EU member states have imposed under the trade agreement different sectoral restrictions on UK firms wishing to trade and provide goods or services. Now, these sectoral restrictions are highly member state specific. So you might get some restrictions in Germany, no restrictions in France, for example. So you do need to check the trade agreement very carefully to make sure that in your sector and what you're doing, that you can still provide the services that you were before we left the European Union. There's some new definitions of workers, and these are within the trade agreement. They're quite specific. And they mean that unless you're in one of these new definitions of workers that the trade agreement creates, then your workers traveling to the EU aren't covered by the trade agreement at all. And then you fall back on the rules of the national member states. Not all of the agreement is adopted in all individual member states of the European Union. They've got some latitude, some flexibility to choose what the rules are and how they adopt them. And what this means is, in practice, the rules of the member state are always the ones that you've got to take notice of first. So whatever the rules are in France or Germany for sending you workers for trading services, for providing those commissioning services that you might wish to do so, it's always the rules of the individual member state that you need to be cognizant of and take notice of and comply with. There were some important old rules on social security coordination that we had as a member of the EU that were very important, and perhaps we didn't in the UK take quite so much notice of as we could have done. Now, these have been rolled over and upheld in the new TCA, the trade agreement with the EU. We'll cover those off in a moment, but it's important to be aware of those. It's also important to be aware of each EU member state can impose its own border control measures. Now, the UK can do that as well. We did that. We've got a new immigration system. But all EU member states now can impose visa or work permit restrictions on UK nationals. And there's a sort of very easy way to remember this, is that if you're a UK national, we're all subject to immigration control when we go into the European Union. Now, that might mean in some cases we have comparatively little to do. In other cases, it might need a visa or a work permit. But the days when we would simply get on a plane or a train with our passport and travel into the EU without having to think, unfortunately, they're now gone. So let's take a little bit of a deeper dive and look into the movement of people. I will deal with the old rules, and I'll hand over to Alice to take us through the new rules. So the old rules for people moving throughout the EU, provision of services short term, well, these were always subject to specific EU regulation going back to 1996. So even as a member of the EU, if we were sending a worker from the UK to France or Germany, and that they were providing a service, and they were going there for a week, 2 weeks, 3 weeks, even for a few days, they were always subject to a specific legal architecture in the European Union. Now, this required member states to notify the other member state if you're sending a worker. So to translate that into very simple language, if you were a part of the EU sending a UK worker to France to work temporarily to provide a service, we had to tell the French authorities, the Labour Inspectorate, that we were sending the worker and provide them with certain information. Those rules still apply now. So if you're sending a worker from Germany to France to provide short-term services, you still need to tell the French Labour Inspectorate before you send the worker what you're doing. So mobile workers always had to comply with local labour market rules whenever they went from one member state to another. And these local labour market rules were enforced by making sure you tell the Labour Inspectorate you're sending the worker beforehand, and then by the Labour Inspectors enforcing the rules by visiting sites where the mobile workers were temporarily working. Now, if the mobile workers and their employers were found not to comply with the local rules, for example, in France or Germany, then the local labour inspector always had the power to levy fines and penalties on the employers concerned. And that could be the company they were working for in France, or it could be the sending employer in Germany equally. So these rules always existed, and they still exist. So those are the rules then, and I'll hand over to Alice to tell us more about the rules as they are now.
Thank you, Tim. So they were the old rules for us when we were a member of the EU. Of course, they are the current rules for existing EU member states. So the only change is we're no longer a member state. And going back to what Tim was saying at the beginning, that single market element that provided that short-term business travel access, we no longer have. So because we're outside the single market, that's why there are, if you like, additional rules on top, or that baseline requirement. So if you try and think of the existing rules EU countries as a baseline for the rules that the UK needs to comply with, if you think about the logic, if other EU member states have to comply with local labour market rules and make advance notifications, that is clearly the least we, the UK, are expected to do. So if the EU have to do it, we do too. And the EU are members, so they get benefits. We're not, so we're never going to get a better deal outside the EU than when we were in it. So think of it that way. The EU have to do it, so do we. But ours is a minimum. So that's why I said think of that as a baseline for the rules that we now need to comply with. So as UK passport holders, we will now need permission to work. And work is quite a vague term, and I know many of you attending today will want to know, well, how do you define work? How do I know if I'm working or not? We'll cover that off in a moment. But essentially, if you're going on behalf of your employer for something that is more meaningful than a business meeting, you are going to need permission for it. So our examples can include providing a service under a commercial contract, so where your employer is contracted with someone in the EU to provide a service, whether that is a sold product or commissioning or warranty, as Tim said earlier, or it may be that you're working for your parent or sister company. These all are situations or scenarios where you would require a work permit or work visa, depending on the language that country uses. On the other hand, if you're a business visitor or even a tourist, we now only have 90-day stay in a 180-day period. Now, that's not 90 days per country. That is 90 days within the entire Schengen area. The next slide will show you a nice picture of what exactly we mean by the Schengen area, because it's quite hard to visualize when I just refer to it. But however, if you are visiting, such as a business visitor or a tourist, yes, you have a cap on the number of days you're allowed to be in the Schengen area, but you should not require or do not require a visa or a permit. So Tim, if we just flick to our map. Thank you. So this map is slightly out of date. You'll see that the grey on the key on the left-hand side says EU countries outside the Schengen area. Now, of course, we're no longer an EU country, but the point remains we're outside the Schengen area. So the dark blue and the light blue, so you can see the map, is what we call the Schengen area. And the Schengen area is essentially where border control has dissolved between those states. So if I was to fly into Charles de Gaulle in France, I'd be subject to border control because I'm coming from the UK. However, if I was to travel on from France into Belgium or, Luxembourg, whatever neighbours France, I wouldn't be subject to the same border control as coming in from the UK because I'm in the Schengen area. So the Schengen area, obviously, is clearly majority of Europe. You've got Greece on the end there. You've got some EEA countries, which aren't EU member states, but they're within the Schengen area. This is the area we're allowed 90 days in. So aggregated, so not 90 days in Norway and Sweden separately, but the entire area. And that applies to tourists as well as business visits. So if you're going on holiday to France for 3 weeks, just take care to note that alongside your business travel. How do they know if you stay 90 days or longer? Well, they digitally log you in and out. And we will talk about some brand new notification systems coming into force next year, which will be mandatory for all non-EU nationals entering the Schengen area. It's not just the UK, it's not just the Brits. This will be for everyone entering the Schengen area. The last thing I would say on the Schengen area is that normally to enter the Schengen area, you would require a Schengen visa. And a Schengen visa is an entry visa, so it provides entry only, doesn't provide permission to work, doesn't provide residence, doesn't provide any sort of thing like that. It's simply an entry visa, a bit like an ESTA if you go to the US. However, the Schengen area, or the EU if you like, decided a list of countries that didn't require a visa for entry because they were on good terms or something like that, and the UK is on that list. So what is called the Schengen Visa Waiver Scheme, the UK is on that, so there actually is no pressing requirement to get a Schengen visa, and they will talk about the benefits in a moment. So Tim, if we flick on to the next slide, we can talk about the new entry system. So we don't have the exact date for when these launch. However, they are soft launching in 2022, and they will become mandatory practice by the end of 2022, so in the next 12 months. So the first thing is ETIAS. Remember I just said that we don't actually need a Schengen visa to enter the Schengen area. We're on the Schengen Visa Waiver Scheme. And normally, if you flash your UK passport at border control, you've established that right. However, the EU want to enforce that a bit more explicitly now. And so all non-EU nationals will need to obtain an ETIAS waiver. Now this lasts 3 years, and in practice it's essentially a security background check process. It wants to make sure that you're not on a terror watch list, or Interpol's not out to get you, or Europol's not out to get you, and so the EU can track who's coming in and out. But that ETIAS waiver that lasts 3 years establishes your visa-free right to enter the EU. And it just essentially enables EU countries to keep better track of criminals and things like that. The second thing coming into force next year is EES, which isn't a waiver, it's actually an entry and exit system, which means it's a bit more proactive, such that every time you travel to the Schengen area, you will have to give your biometric data at some sort of kiosk, which will normally be eye scan, face scan, and your fingerprints. You'll have to do that upon entering the Schengen area and exit, and that's each time. However, if you're traveling by train, ferry, or car at Dover or Folkestone, the kiosk or the biometric data will be collected UK side of the border instead of flying into Europe and taking it there. So that's
Hi, I think I'll just pick up at that point, Alice. I was just going off for a second. So we've just explained about the EES system, the entry and exit system that requires all travellers to the Schengen area to have their biometric data. This is to make sure that, quite frankly, that you are who you say you are. That when you go in, that the passport matches the traveller. That's to make sure that the EU know who is coming in and out of the Schengen area. The Schengen authorities know who's coming out of the Schengen area, and it will make counting the days and identifying the people an awful lot easier than it used to be under the old system where passports were stamped. So as we'll come on to in a moment, whilst we might have a Schengen waiver scheme for UK nationals, the 90 days now is going to be more rigorously enforced. And it'll be more rigorously enforced because our biometric data will be taken every single time we go in and out of the EU or the Schengen area. It could mean that actually traveling in and out is a bit slower than it was in the past. But what it will mean is the rules will be more rigorously enforced, because automatically, electronically, every time we go in or out of the Schengen area, everyone's going to know about it because our fingerprints, our biometric data will be recorded. Apologies, Alice, I was just rounding off there. Shall I hand back to you?
Thank you. So this was just to get people to acknowledge that whilst it may be very difficult to imagine that we're going to be subject to different rules, I think it will hit home quite hard when these two new systems come into force next year. So we will have no choice but to be subject to border control and border checks, such as biometric data and the ETIAS waiver. So if people think, well, no one asked me any questions at the moment, well, you've only got so long before they do, because you will be subject to those border controls. So moving on from that entry to the Schengen area, we'll stick with no visas or no permits for now, and what is a business visitor. So a business visitor will be someone who shouldn't require an entry visa, a work permit, or a work visa. Those sort of immigration/work permissions, a business visitor will be exempt from those purely because they should be simply visiting, and the activities they undertake should be quite trivial in comparison to other activities that generate remuneration for their employer. So firstly, you don't self-diagnose yourself as a business visitor or a worker or whatever you want to call yourself. It is up to the EU member state to define you. So each EU member state will have its own exclusive and limited list of activities that a business visitor is allowed to undertake. Now, some of them overlap, some of them vary vastly. So you can have some countries with a very long list of what you're allowed to do as a business visitor, and then another country which only has about 5 things on it. So it may be you find yourself qualifying as a business visitor in France, for example, but if you were to go to Poland, you may not be allowed to do that same activity without the need for a work permit. So please, please, please bear in mind that your business activity and the permission to do it without a visa or a permit will vary according to the country you're going to. However, there are some very common examples. So you will find that you are allowed to attend business meetings in pretty much all EU member states. And the same goes for conferences and attending trade fairs and seminars. Generally speaking, you can receive classroom-based training, but you cannot provide it. There are a couple of member states who allow you to provide training, but I would say the general rule is that if it's practical or vocational, you're probably not allowed to provide it without a work permission. You can normally sign deals and contracts and negotiate with potential clients. However, the bottom line is, to get you into the right mindset, is that you cannot provide a service to a client, you cannot work, you cannot receive local remuneration. However, you will need to prove you are a genuine business visitor. So if you go to the next slide, when I say genuine business visitor, essentially, they're not really going to take your word for it. Otherwise, to avoid getting visas and work permits, which I couldn't be bothered to do, I just say, I'm a business visitor, let me in. Well, in that case, everyone would try it on and try and get away with it. So they will try and question you. You will have to rebuttably prove that you are genuinely a business visitor and not trying to avoid getting out of a visa or a permit or something. So there's a standard Schengen list of documents that help you prove who you are and what you're doing. And these may be tweaked according to each country, but generally, they're going to be the same. So you need a letter of support from your employer sending you, explaining the nature of the trip, what you're doing, where you're going to be staying, and that confirming you're employed. The host EU company who's hosting you will need to send you an invitation letter, essentially mirroring the letter that your employer is sending. You will need Schengen compliant health insurance. Please note, this is absolutely not travel insurance. It's not the same thing. It's health insurance. It's taken the place of a e-hit card. Some of you may remember what that was. And it may be that your existing policy provider already does health policy, but just double check. When we say Schengen compliant, we mean a minimum coverage of 30,000 euros per person. So starting off, I'd check with your current policy provider if that's provided. If not, we can provide a list of other policy providers there. Fourthly, you will need to prove you have sufficient funds. That's to ensure you're well covered for your stay. Your employer should be meeting those allowances. You may be asked to show an A1 form. We will cover Social Security in a minute, but the A1 form is a term for a certificate you obtain from HMRC to show that you pay UK NICs. Proof you're returning to the UK, which would be your return tunnel tickets or plane tickets, and proof of where you'll be staying, which should be prepaid accommodation. So again, you may not be asked for the full list, the complete list, but that is the list most border police will use to try and get you to demonstrate that you are a genuine business visitor and you're not working or you're not eligible for a work permit or visa. Tim, should we just move on to there we go, what time of work am I? Help. So firstly, like business visitor, each EU member state will have a different interpretation of what work permission is needed for different sectors and different job roles. So don't panic. We have just discussed business visitors on the previous slides, and it should be clear upon checking the individual country list that if your activity is not on that list, you're very likely going to need a work permit or work visa. Please do not try and self-diagnose yourself. You do not define your status by the length of time you stay in the EU. Even if you go to Belgium for one day, that doesn't mean suddenly you're exempt from a work permit if you're still doing work on that one day. So the length of your trip doesn't diagnose you as a worker or a business visitor. It's your activity you're doing. So I could require a work permit, even if I'm just doing one day of work in Belgium, because that's the rules, or France, whichever country it is. So try and get to the mindset, just because it's a short trip, doesn't mean you're suddenly exempt from any work permissions. So check the specific country list on business visitor activities. If you're not on the list, you will have to prepare yourself that you will probably need a work permit of some sort or work visa, depending on the language used by the country. They use both those terms, unless you're lucky enough to fall under an exemption from a work permit, but we can help with that. One thing we would say, if there is a trip coming up where you think, I think I'm in work permit territory, apply for it now, because the processes to obtain a work permit or a work visa can take 2 months. Could be shorter, could be longer, but that's the average time we're seeing at the moment. Normally, the process of getting a work permit, it's fairly straightforward. You probably need some help in determining which is the correct permit or visa you need, what supporting documents you might need. You might need a solicitor to authenticate them. You may need to get professional qualifications recognised. We'll move on to that in the next slide in a moment. But normally it's your application form and an in-person appointment at the embassy or consulate to take your biometric data. Finally, if this needs saying again, if you do require a work permit, it's for each country. There is no EU-wide rule. There is no EU-wide permit. You need one for each individual country that you go to. It might not be sustainable if you have 30 employees going to 27 different countries. That's a lot of work permit applications. So it may be that you need a different business strategy. Anyway, moving on to what sort of things to expect from you when you apply for a work permit, or if you're providing a service which would make you eligible for that work permission. So alongside your personal details and the company or employer details, these applications do require a lot of information, but by way of documentation, by way of supporting evidence. So they want to know who exactly your client is. They might want to know your client's company number, your client's ID number, their address. They will probably most likely want to see your direct contract between you as the UK company and the European company as the end client. If you do use a middleman, such as a distributor or a supplier or contractor, it might not stop your work permit application, but it will probably likely mean that they require more documentation of you to explain the situation, because the preference is, after leaving the EU, that they want a direct contract between clients without subcontracting, if you like. They want to see evidence that the worker being sent is employed, because there's completely different rules for agency workers and self-employed people, completely different rules. So they want to have evidence that you're employed and evidence of your wages. This is to ensure compliance with local labour market rules that Tim was speaking about earlier. They're found in local collective agreements, and essentially they dictate the minimum wage for that sector and that country, and they will dictate the maximum working hours for that sector and that country. So essentially they want to know that you're being paid at least above the minimum wage for that job role, sector and country, and they want to make sure you're not going to be working more hours than you're allowed to do for that sector, job and country. Finally, they want to know your length of employment. So they want to see that you haven't just suddenly been employed yesterday to get around the self-employed rules, for example. They want to see 6 months or more, or probably a year or more. And they may want to see your professional qualifications or evidence that you are professionally qualified to do that certain role. So if you work in a heavily regulated sector, for example, such as pharmaceuticals, or manufacturing as a broader sector, there will be health and safety requirements and compliance required, as well as whether that country has required that worker to demonstrate their competence by way of the professional qualification, as opposed to years and years of work experience. Tim will speak more on that on the next slide. And then finally, what exactly will you be doing? What is the service? They'll get some idea from the contract. You'll need to give some sort of evidence as to why you're there and who's going and for how long. Finally, once you've obtained your work permit after submitting all of this, you may be required to submit an advance notification to the local authorities that you are sending workers. So this would normally be creating an account on a portal, uploading information about your workers. It may be uploading documents, it may be uploading information in the spreadsheet, it may just be filling in a form. All the countries' portals differ, but essentially every country has a notification portal. European member states use it. I think we could as well. Essentially, you probably need to use a bit of Google Chrome and translate, but that's about it. And you notify the country in advance that you were sending the workers, so as to ensure you admit and state you're complying with local labour market rules. We'll leave it there on work permits today. I'm conscious of time, so Tim, can you take us through professional qualifications, please?
Thanks, Alice. Yes, so professional qualifications, what are they? Why are they important? Probably know what they are. I mean, any qualification that anyone in the UK has, it could be a degree level qualification, could be a non-vocational qualification, it could be level 3, level 4, etc. So all these bundles of qualifications that we're talking about, well, they're now not automatically recognised in the European Union anymore. So this is a common theme of what we've been talking about today. When we're members of the EU, we're part of a pan-European system for the movement of people. We spoke about the rules back in 1996 and onwards. Qualifications were used to be part of a pan-European system where our qualifications could be automatically recognised. And now they're not anymore because we've left. And the agreement with the European Union, whilst there is some coverage for this, it's going to take some time for us to get to a point where our qualifications are automatically recognised uniformly again. UK mobile workers will frequently rely on their qualifications when providing services. These could be technicians, they could be engineers, they could be consultants, there could be a range of people. It's not just accountants, lawyers, doctors, dentists, vets, regulated professions that we're used to dealing with in the UK. It's anyone that's got a qualification that is necessary to do their job when they provide a service in the EU. Often getting a work permit will depend on you having a recognised qualification. If you come into the UK and you want a visa, then you need to prove that your qualification is equivalent to a qualification in the UK, whether that's a technical qualification or a degree. Flip the coin, if we go into the European Union, it's the same system again. If we want to get a work permit, very often they want to know that our qualification is equivalent to a local qualification. Contractual obligations might impose competency requirements, qualification requirements. It may be that you're required to provide a warranty or a service, and that under that agreement with your EU customer, you have agreed that you will provide someone that is suitably qualified under local laws to do the job. In that case, this is an issue for you. In practical terms, we're less likely to win business if we can't deploy qualified people to the European Union. In Germany, for example, most branches of manufacturing, whether they're electrical or mechanical, are regulated under the local laws of Germany and require people to hold local qualifications. So if we are sending people to these jurisdictions and we're sending them to perform work that is regulated locally, then we need to comply with their local laws, which is essentially the same message that we've been giving you today in terms of work permits and immigration requirements. Insurance requirements, again, under EU or local law, may impose health and safety requirements, might impose the requirements to have local qualifications recognised. This is just a bundle of issues that you need to be aware of. Insurance, work permits, contractual. What are the local rules for this particular part of the labour market? So we need to know what qualifications our UK workers hold. We need to determine whether they're recognised in the EU member state that we're sending them. And in keeping what we heard from Alice a moment ago, the rules are different for each EU member state. It will come as no surprise to learn that the qualification from the UK might be recognised in Germany, it might not be recognised in France, it might be recognised in Italy, it might not in Spain. This is a process now of checking each individual member state to find out if you are sending someone with a technical, a vocational, or an academic qualification, which is necessary to do their job, whether that individual country any longer recognises the qualification. And this can be a real blocker, because if the work permit that you need requires the qualification to be recognised and you haven't gone through that loop, then you need to go through that loop first before you can even apply for the permission to work. This could add on several months to the process of deploying your workers to the EU. That's why this is important, and it applies both for people coming into the UK and for people going to the EU. So that's the word on professional qualification. If you need to know more, contact us. There are organisations in Europe that deal with this, but I'll hand back to Alice to deal with social security.
Thanks, Tim. Just cautious of the time, so we will quickly stop on social security for a moment as some penalties, fees and fines, and then we'll move on to the new immigration system that the UK has. So social security, another name for national insurance, so it's what is known as UK NICs in this country. We all pay it if we're employed, well, otherwise as well. Essentially, there is a very archaic rule that if a worker was to work in another European member state for whatever period of time, he would be subject to that local country's social security coordination or national insurance, which is very unfair because that meant a lot of employees were paying twice. They'd be paying national insurance for their own country and paying it for the time they were abroad as well. So there was a rule that was called the don't pay twice rule, if you like, but it applied to EU member states. We left. However, that rule was rolled over into the Trade and Cooperation Agreement. Instead of it being a solid principle, it's an opt-in, opt-out principle. Luckily, all 27 member states have opted in to this agreement. So at the moment, we still fall under the don't pay twice rule, provided we follow a process. So in order to be exempt from paying social security when we work abroad, we have to prove we already pay it in the UK. And the way to prove it is to get a certificate from HMRC. You use your government gateway portal, either as an employee or an employer, doesn't matter. You log in and you apply for an A1 form. It's not called an A1 form on the HMRC website. It's called a CA3822 form or CA3821. However, we can provide links and help with that after the webinar. You have to fill it in for each trip and each person, which is a bit of a faff, but the dates on your A1 form have to match up, obviously, with your dates for travel, because you're exempting yourself from the time you're in a specific country for a specific time. So you can't get an A1 form that does the entirety of the EU. You have to get an A1 form for each trip, whether you're going to Germany, France, or whatever. So that is a bit on social security. So you can prove you pay UK NICs by getting the A1 form from HMRC. If you can't prove you pay UK NICs, then you will be liable to pay local social security for the time in that country. Moving on to, very quickly, penalties, fees and fines. So we've talked about compliance with local labour market rules, we've talked about compliance with immigration permission and compliance with work permission, and just now compliance with social security obligations. These are all within EU law. So effectively, if you don't comply with all these different things, you are found to be breaching European law, EU law. That's the scary thing of it. Further, the guards at the border, they're not border guards, they're border police. Many of the European countries have border police at the border. So it is very, it's taken very seriously within Europe, but not so much in the UK because we're not used to complying with all these things. So non-compliance with union law can result in both the sending employer, us, the UK, and your client being fined. It's a lot easier to fine your client in the local country, isn't it, than chasing after someone who's flown back to the UK. You will lose a lot of business that way if you keep not complying and your clients keep ending up fined. Fines usually 10,000 to 15,000 euros per worker. The worker doesn't get personally fined, the company does, but they will fine you according to how many workers breach certain rules. There's enforcement with ETIAS coming next year. There's enforcement with entry and exit system coming next year. There's enforcement at the border. There's enforcement by visiting labour inspectorates at your site of work. There's enforcement by your client who doesn't want to get fined. Maybe your client reports on you. There's enforcement via the advance notification that you should be sending. So increasingly, we're being squeezed and squeezed and squeezed into complying with these rules, because as we go forwards, there's fewer loopholes and less flexibility to try and avoid getting caught or flying under the radar. So whilst no one wants to be scaremongered, they have to be aware that non-compliance and deliberate non-compliance will result in some form of penalty or fine. So just to make sure you're aware of that, that's why these rules are in place, they are enforced. So with that done, I think we're moving on to the UK's immigration rules. We've got some time to quickly go through them. The reason why we're going to touch them today is because there's been a huge interest from UK members about the requirement for having to have a sponsorship license, not necessarily because UK members want to permanently recruit non-UK nationals, but perhaps they want to bring them in on a project-based basis, perhaps 3 months, 6 months, 12 months. And they're finding out that they need a sponsorship license for all that. So Tim, do you want to talk about the points-based system as an overview, and then we can get into some of the details for the individual routes that might be of use and interest to UK members?
Sure, thanks, Alex. So the UK new immigration system coincides with the trade agreement coming into force. We've said that EU member states can impose border control measures, or we have, and these are them. So we have a points-based system. We assign points to people want to enter under a visa required route. The points are based on a job offer from a sponsoring employer, having a job at the correct skill level, English proficiency, and salary above a base threshold, 25,600, or something called a proportion of the going rate for the job. So the salary threshold is variable. It's not always 25,600. In circumstances, it could be below that, or it could be above that. So please don't take it as read that 25,600 is what you need to pay. Employers need to get a sponsorship license if they want to recruit a non-UK national. So if you want to recruit someone, they don't have a permission to work in the UK, not a UK passport or an Irish national, then you will need to get a sponsorship license before you can even employ them. So major change. Before Brexit, clearly we could employ French and German workers in the UK without going through the UK immigration system, and now we do. So now we need to think about getting sponsorship licenses for non-UK workers. Each role has a code, so a job role has a code, and that's found in the immigration rules. And with the code, you can then see what you need to pay, what the going rate for the job is. So employers recruiting for roles can't generally offer a salary less than 25,600 or the going rate for the hire, unless you're on something called the shortage occupation list. It only applies to tier 2. So a bit of work to do there around what you need to pay. And if you're thinking about recruiting a worker in the first place, you do need to make sure that you've got a sponsorship license. So shall I hand back to you, Alice, to go through the various tiers that exist in the UK and the main buckets that there are?
Thank you, Tim. So broadly speaking, very quickly, there are 5 routes. There are others, but these are the main sponsorship routes. So tier 1 will not apply to employers. There's no sponsorship required, first of all, but it's aimed at entrepreneurs, PhDs, and those who are going to invest in Britain. But the route is capped. Tier 2 will be the main route for anyone who wants to permanently recruit someone, or who wants to host a colleague from a parent company. So that's an intra-corporate transfer route. So if you have colleagues in a sister or parent company in Europe or elsewhere even, then you will still need a sponsorship license, and they'll come under tier 2, not skilled worker though, but tier 2 ICT. So the tier 2 route, either skilled worker or ICT, requires 70 points. It's a very costly route. You need to pay for the sponsorship license. There are visa fees to take into account for the migrant and possibly their family. And then there's some mandatory surcharges as well. So you've got the mandatory annual skills surcharge, which is payable by the sponsoring employer only. You've got the mandatory annual health surcharge, but either the migrant or the employer can pay that. And then the license can cost between sort of 530 to £1,500, depending on the company size. They take into account balance sheet, turnover, and headcount. Tier 4 is the student route. This is for students wanting to apply with an accredited provider. It is not for internships, it is not for student placements, it's not for work experience. That is not what Tier 4 is intended for. If you do have those sort of queries, come to myself or Tim or Nicola, who can help you with that. But Tier 4 student route is not for internships, it's for foreign students to go to university only. Tier 5 is an interesting brand new route. It's called the Temporary Worker International Agreement route. You may have guessed it has been born out of the new trade and cooperation agreement that we had with the EU. Essentially, again, you need a sponsorship. It's for a contract for the supply of workers from somewhere else for the benefit of the UK company sponsoring them. So you can't subcontract them out. You can't bring in workers to then service your UK clients. You have to benefit from their work. And they can only stay for 12 months maximum. It's aimed at those inbound postings and those contractual service suppliers only. The interesting bit here, and it also applies to Tier 2, that if you do want to bring workers in for a project for 12 months or less, you do have to offer the role to the UK labour market first. You do that open tender before offering it to a non-UK national. The earliest visa application has to be 3 months before the start date of them coming here, and their health surcharge is also applicable, so they will still have to pay towards using the NHS. So there's a brief rundown of the routes. Tim, will you just quickly go on to, I think, Tier 2? So again, if you want to employ non-UK nationals, you need a sponsorship license, and you need to prove to the Home Office why you're intending to recruit from abroad. You need to obtain a certificate of sponsorship for each migrant you intend to sponsor. The migrant cannot apply for their visa until they receive their certificate of sponsorship. This can be costly, I've said before, because the employer will need to pay for their sponsorship license, they will need to pay for each cause they give to the migrant, they need to pay the mandatory skills surcharge, possibly the health surcharge, and possibly contribute to the migrants' fees as well. So also the migrants, whilst they're obtaining their visa documents, they need to take an English proficiency test in their country of origin. And they may need help from their employer with a visa application as well. Again, you've got to prove to the Home Office that you have conducted a recruitment exercise to the UK labour market first before you recruit from abroad. And that does apply to the ICT route as well as the Tier 5. Again, to get the points, you've got to offer the job at the correct skill level and salary level and show to the Home Office where the new job role is going to sit in your company hierarchy. So it's a very quick run through of what you're expected to do when you apply for a sponsorship license for Tier 2. Moving on just quickly to Tier 5. Again, as I said, new trade agreement deal. Most importantly, if you are going to bring workers in from Europe or elsewhere under Tier 5, you must benefit from their services. You cannot use them to subcontract to other clients. You cannot bring someone in from Italy to go and provide a service to a UK client. You cannot do that third-party subcontraction model. You must be benefiting from them. So it has to be a commercial agreement between that company and you. The Tier 5 workers would remain employed by their employer in the EU or elsewhere, and they're simply servicing you under a direct contract. So lastly, if you are going to bring someone in under Tier 5, they cannot be from the same corporate group. That would be ICT. So remember, if it's your sister or parent company, they're not eligible under Tier 5. So they would have to come in under the ICT route. So essentially, you cannot supply foreign workers to your UK clients for those services because that's against the rules. You'd have to employ them if that were to be the case. And I think, Tim, that's all we've got time for. I'm just noting the time. We've got business travel. Do you want to just cover off business travel to the UK quickly?
I'll just say a few words. So as much as business travelers can go to the EU, we've got rules for the UK. You can come into the UK as a business visitor. We've got some indication on the slide there of the main activities that you come in: attending meetings, conferences, trade fairs, promotional work only, giving briefings, gathering information. The important thing is you can't be paid in the UK. You can't work directly with customers and clients. And the business visitor rules mean that effectively you're flying in, you're flying out over a fairly short period of time. And what you're not doing is undertaking direct employment in the UK. These really are strictly business meetings or going to a trade fair or something of that nature. So we've got another slide on ICT, intra-corporate business visitors. Just a quick word. Yes, they can come in, they can advise, troubleshoot, and provide training or share skills and knowledge, but this is internal project work only. They can't actually work with the customers or clients of the UK company that is part of the wider corporate group. So that's just a few words on business visitors and ICTs. At this point, Chris, I think I'm handing back to you, or is it Fergus, for the next part of the webinar?
Brilliant, brilliant. Thank you, Alice and Tim. And just very quickly, of course, we're getting a mixed feedback in terms of the audio quality. If you are having any issues, apologies. To reiterate, we are recording and sharing that recording and the slides following this session, and we will, for future sessions, look at where we can be a bit more resilient with that for any ill experience. We have had a number of questions, so there's still time to pop a question in the Q&A chat box at the bottom of your screen, so please make use of that. But before we do, I will launch our quick poll to get your feedback and so we can understand where perhaps the sector is and you guys are with your business travel to the EU. So I'll leave that poll up on your screen for a couple of moments and then we'll go through the results. And in the meantime, if I could just ask you to stop sharing your screen. Thank you, Tim. This will take a couple of minutes. We do have quite a few questions, but please also feel free and welcome to enter the poll. We will not be sharing any direct results, or any answers will not be identifiable directly to you or your business either. I've just seen a couple of your comments in the chat, so if we can just relaunch that quickly, and hopefully you've had time to check the questions and rerun that. And apologies for that. So hopefully you can now see that on your screen. So apologies and thank you very much for answering. See, we're getting some results coming in now, so thank you very much. And we're still getting responses, so we'll leave it another 40 or 50 seconds or so, and then we'll go through the results. Thanks for your patience. And we'll give it 10 more seconds. Go from there. So thank you very much for putting that in. So hopefully you can see the results on your screen. If you can't, as a very quick run through, do you know how many of your workers travel to the EU and to which countries? Just over half saying yes, my company travel, all the travel agent logs all business travel, so very much mapping out at the business, and actually only 4% allowing workers to conduct their own travel by themselves. Do you know why your workers travel to the EU? Absolutely nobody is unsure of the reasons why. 33% are sometimes aware but don't always keep track, and 67% are keeping track and very much aware of why workers are travelling. Since the UK left the EU, UK nationals are required to obtain a work permit or visa if they are required to provide a service in the EU. Are you confident of whether knowing when they require this? 35% are aware and yes, 15% are not aware, and then there's quite a large amount, just over half, are aware but unsure of which workers are available to this. In terms of social security rules, a third are aware but do not know how to prove the exemptions. 47% are aware and do know how to prove exemption, and then 20% are not aware at all. And are you aware that when workers travel for work in the EU, sometimes they need to notify local authorities in advance to confirm they're complying with local labour markets rules? 29% saying no and do not know where to do this. 60% saying they are aware but not sure on all where to do this, and only 11% are fully aware and know how to comply. Do you know that all days time spent in the EU country, both for business and personal reasons, count towards the 180 days that Tim and Alice have mentioned? Nearly half saying yes, but we do not ask workers to share this information with the business. Only 18% are aware and do also ask for personal information of personal trips, and 33% not aware at all. And did you know while you're working may be able to travel to the EU for a short-term business visit without a visa for limited circumstances, and different rules for country to country? 62% are aware that different rules apply. 24% are aware but thought there was one set of rules for the whole of the EU, and 50% totally unaware, and a proportion looking for further support with business travel at your firm. So I'll stop sharing there, and thank you very much for your patience with the polling there, and hopefully some useful insight into how others are finding this as well. And as I said earlier, at the start of the session, that's very useful intelligence for us when talking to government, both here, but also when my colleague Fergus, who's on the call, sat in Brussels, is talking at the European Union about how we're experiencing conditions under the Trade and Cooperation Agreement. So that being said, if I can hand over you, Fergus, to chair our Q&A session. We have had a large number of questions, so we'll try and get through all of them, but if we don't, we will also follow up directly with you as well.
Chris, thank you very much, and good afternoon, everyone. I'll try and group these questions together. So looking at that first issue around the 90 days and business visitors, then looking at some of the new systems which the EU are bringing in terms of the entry and exit systems, then look at some of the issues around working and social security and taxation, and finally look at some of the issues associated with travel to the UK, trying to then mirror the order we had the presentation in. So Tim and Alice, the first question to you from Debbie. Have I understood this correctly? If we have a traveller going to France, for example, for regular meetings or a conference, and they are allowed to go in for only up to 90 days per year, this would also include any days they may use to go on holiday with no visa required. Is that true?
There's a little bit to unpick there, Fergus. So firstly, you're correct, meetings or conference will probably mean that you are a business visitor. So that's a good starting point. It's not 90 days in a year that we get, it's 90 days in a rolling 180-day period, which is roughly about 6 months. There's a link to a Schengen calculator, actually, that I know Fergus has sent out previously, which allows you to count your days. And then thirdly, you are correct. Business visitors and tourists, i.e. when you holiday, all of that is taken into account with your 90 days. So if you go 3 weeks in France on holiday and then 2 weeks to Germany on business, you have still used up 5 weeks of your 90 days.
Thanks very much, Alice. And a similar question from Manella, which looks at service engineers from the UK who are required to travel to the Czech Republic for up to 3 months. And understanding the new rules, again, only 90 days in any 180-day period. How will it affect going on holiday? And is it better, therefore, to apply for a visa?
Yeah, shall I take that? So, I mean, the answer is we've already covered the 90 in the 180 period, and we've got the calculator link that we can circulate. You can apply for a Schengen visa called a C-type visa. You can't just actually apply for the Schengen visa you want, probably. The Schengen visas are issued in the country that you want to travel to. So if you're traveling to France and then you want to come back, you want to travel to Germany, they're all in the Schengen area. You only get one C-type visa to begin with. You can get a single entry, you use it up. You get a double entry, you use it up. You then get different types of multiple entry visas. So whilst you can get Schengen visas, which will help, 2 points. First of all, you can't actually get a visa to cover you for multiple entries very easily. You've got to use up the single and double entry. And you're still subject to the 90 days in 180. You can't leapfrog that by just getting yourself a Schengen visa. Essentially, they might help at the border because the list of documents that Alice spoke about during the webinar, you don't have to have that list of documents with you. But it's not going to get you over the 90 in 180 issue. And you're not simply going to get a multiple entry Schengen visa if you're not regularly going to the Schengen area to begin with and have used up those single entry, double entry visas to begin with. So possible, Fergus, but it's not a silver bullet.
Tim, thanks very much for that. I'll take a next set of questions sort of together because I think they're all in reference to the EU's new entry and exit systems and the ETIAS, which will be launched over the course of next year. One question looking at what's the exact sort of launch time for that? Understand that it's going to be implemented from the 1st of January next year, but fully required by the end of the year. Question here on the biometric data, and do we know who will hold that data, how long it will be held for? And if you refuse to provide that data, does that mean you will not be allowed entry? And a final question on this in terms of the system, will this be for all types of travel? So will you have to submit information to the entry and exit schemes if you're going for a business meeting or for a conference, for example, under the business visitor? Thanks very much, Tim.
Well, the answer is yes to the lot, quite frankly, Fergus. Rather flippant response, I'm afraid. But the point is this: when you come into the UK, we have border control. You go into the Schengen area, they have border control. This is just the EU enforcing the existing rules in a better, more modern way than simply looking at you and looking at your image and deciding if you've got a passport and stamping the passport. This is updating the rules, if you like. Can you refuse to provide the information? No, because it's a requirement of the entry and exit system. The ETIAS is like a permission that lasts 3 years. That's fairly straightforward. You're simply registering yourself on the system, as Alice explained. Essentially, it's a test and a search of various criminal databases. But for most visitors and for most people, that's not ever going to cause an issue at all. The EES system records our biometric information, which means it needs to be taken in the first place and checked every time, both on entry and exit. Can we refuse? No. In as much as could we refuse, or could anyone come into Heathrow Airport and refuse to speak to our border officials? No, they'd just be refused entry. Where's the data kept? On various databases. That's quite a good question. So there's a central database that deals with the Schengen area, Schengen visa system and the waiver system, but also the data is going to be shared with the individual member states as well. It's going to be taken in a lawful and compliant way, so that there's no doubt that the data will be handled correctly. But in terms of exactly all the databases that are going to be checked, we don't actually know at the moment, save that we can say this. The whole point of the entry and exit system is to make sure that you don't stay 90 days in more than 180. And therefore, the data will at least be shared with the immigration authorities of the member states that are signatory to the Schengen Convention. As Alex explained, that's the 27 member states of the EU plus the EEA as well.
Thanks very much, Tim. Moving on to questions about working in the EU. I have a question here from Caroline on the intercompany transfer visa route. Is it also the case that this will be subject to a time limit of 90 days?
I presume you mean an ICT visa into the EU as opposed to into the UK. In the UK, we do not have a 90-day rule. That is a Schengen Area policy, of which we're not part of. So if you do get a visa of any kind, whether it is ICT or a work visa, you won't be subject to the 90-day rule, because that is only a rule that is triggered to those who visit. Because if you want to stay longer than 90 days, you then get a national visa, or you get a residence permit to give you permission to extend your stay. So if you have a work permit that's valid for a year, or a work permit that's valid for 2-3 years, then that is the length of time you're allowed to stay and work in that country. You may also need to get a residence permit. So if your ICT visa is 6 months long, then that's how long you can stay. So the 90-day rule is not triggered once you get your work permission, because you've been given permission to work. The 90-day rule is for those who do not have permission to do anything other than visit. So that's why you have the 90-day cap. So it should only apply to tourists and business visitors. So if you've got a permit or a visa, your eligible amount of time to stay in that country is according to the validity of that work or residence permission.
Thanks very much, Alice. And again, I'll try and take a few questions together here. A question here for whether visas and permits can be used for multiple trips. A question here about what are the consequences if you are found to be working without a permit where it was required. And then a question around trying to understand whether EU nationals working for UK firms also require these permits or also have the same obligations for business visits. Hopefully you can take those questions together, Tim and Alice.
So the first one, I think, was sort of obligations and consequences, etc., and time. So if you get a work permit to work in a European country, then you're only working in that one European country, as Alex explained. There is no sort of pan-European work permit where you can work everywhere. And the work permit will last however long you apply for, however it's granted, 1, 3, 5 years or so. So if you get a 3-year work permit for France, you can keep going back for 3 years, all is well and good. So you don't have to apply for the work permit every time. There's an upfront cost, if you like, in terms of time. The financial cost is very small for these work permits, but it does allow multiple entry and exit. The consequences of not complying, well, if we flip that around to the UK context, there's probably no one on the call today that would probably employ someone in the UK who didn't have an immigration permission, because the consequences are criminal liability and also civil fines and penalties. Flip that around to the member states of the European Union, it won't surprise anyone to know that the consequences of illegally sending someone to work in the EU is for your company, for you personally, and for your client and customer in the EU, civil fines and criminal penalties. As Alice explained, it's a lot easier in terms of civil penalties to fine your client or your customer in the EU. So, and these, as we put on our slide, as Alice explained, were 10 to 15,000 euros per worker very easily. So the consequences of not complying are that you run the risk of, first of all, incurring the cost and penalties and fines yourself, but also that your client or your customer could incur the cost and fines and penalties themselves, either now because they're inspected when the worker's on site, or there's an inspection in 6 months' time, they go back through the records and find there was a UK worker there who didn't have the correct permission, in which case they get fined in 6 months' time. So these are very real, serious consequences of not complying with the rules. Apologies, folks. I think there was one more point at the end you want to wrap up to this section.
Thanks very much. Just in terms of the requirements for EU nationals, so EU nationals working for UK firms, what are the obligations there?
So EU nationals who are working for UK firms, is that in the EU? Is that what the question meant?
That is in the EU. That's right, Tim. Yes.
So a UK national working for an EU firm or would simply, your UK national permanently working in the EU, then you need permission to work there permanently in the EU. That's sort of fairly straightforward. You don't need a visa or your work permit or residence permit if you're permanently based there. So, and that's sort of fairly straightforward. I suppose the only exception could be, Fergus, is if you had a UK national perhaps in the Netherlands who was in the Netherlands whilst we're a member of the European Union, and they have got a permission to continue to work in the Netherlands or wherever they were under the withdrawal agreement that we had with the EU, in which case that particular UK national can get their rights preserved. They can continue working in the Netherlands. A point that's worth making is the permission under the withdrawal agreement allows them to work in the Netherlands in that scenario. It doesn't allow the UK national then to go to France or Germany to work. They're just stuck with the Netherlands.
Thanks very much. I've a question here from Lisa, and hopefully I'm getting the my understanding of this question correctly. So an employee of a UK firm who is being hosted at an EU site, but is undertaking work which primarily and only involves meetings with UK based individuals replying to work which is being undertaken in the UK, having Zoom meetings, etc., and working on projects which are specifically for a UK employer, but that person is based in the EU. I think I'm getting that right, Lisa, and hopefully Tim and Alice can shed some light on this. So an individual based in the EU, working in the EU, but the work is essentially conducted on behalf of a UK organisation. Do they still require a permit?
Well, if they're an EU national, Fergus, then of course they have the right to live, work and study throughout the EU, and there's no work permit ever going to be required of them. From what you're saying, I think they're employed by the UK company, but they obviously are resident in a European company. The only issue with that is you don't need a work permit or a visa because you're an EU national, you have that right to live and work there. The issue would be is your employment contract compliant with the way you live? Let's say you live in Spain. Does your employment contract have local employment terms and conditions incorporated? Are you still paid your UK salary? Should you be being paid by a third-party payroll provider? Do you need to notify HMRC that this is someone that is employed by my company but lives abroad? There's lots of various employment HR issues in that scenario as opposed to immigration issues, is what I'd say. So if you do want to double check that's all well, then please do drop us a line.
Thanks very much. I have a question here from Dave Latimer, which talks about sending their technicians to Norway to complete a week of work commissioned and funded by a grant project. Do they still need a work permit and a visa?
That's one we would need to come back on, Fergus, check exactly. So so first of all, Norway, not an EU member state, but member of the EEA, so they have to comply with single market rules. But when we go into Norway, we're going to be complying with the rules of Norway. Whilst it's not part of the EU trade agreement, the UK did do bilateral deals with the EEA and Switzerland and other countries that formally were part of the single market rules. Most states within this orbit generally have rules that provide some exemption if you are selling goods and then going to commission, store, maintain. I say some, they are incredibly member state specific. It depends on the direct contract that Alice spoke about earlier on, and it will depend on exactly what you're doing in those circumstances and the way that particular country has decided to frame that particular exemption. But they do exist. So the answer, I think, Fergus, is that's one where probably they'd want to come back for a call with us separately, so we could work out exactly what the contractual situation is, what they've sold to whom, and what they're doing in Norway, and then we can take it from there. Apologies, not capable of a precise answer.
No problem at all. As Tim and Alice have said, for any detailed questions, we are happy to follow up if you'd like to send them to our inquiry line, which I'm sure Chris will remind us all of at the end of the session. Tim and Alice, a couple of questions here very specifically on the aviation sector. One question here is, are aviation workers, engineer and repair and maintenance specifically in this question, exempt from work permit or visa requirements? This industry obviously supports critical aircraft repair activity, which requires travel and work on very short notice and often in the same day. So a reflection on that. And finally, one about trying to understand how work is determined, who defines what work is, and how do you best account for that, whether the work is being delivered on a short-term basis or not. Who decides whether work is being undertaken?
Thanks, Fergus. So firstly, your status is not defined by the length of time you spend in the EU. Forget it. If it's a short-term trip or a long-term trip, it doesn't influence whether you're a business visitor or a worker. That's the first thing. As we said before in the webinar, each EU member state or EEA country, so Europe if you like, has a specific list of business activities you can take as a business visitor without a visa. If your activity that you are doing is not on that list, we have said, don't try and push it. You can't self-diagnose yourself. You are probably very likely going to need a work permit or work visa. Don't get confused between the two words visa or work permit. If you look at them in isolation, they mean two very different things. But Germany calls it a work visa, France calls it a work permit. They're the same thing, it's just immigration permission. Thirdly, you spoke about the aviation sector. Well, it's going to be different for each EU member state. You may be exempt from a work permit in France, but not in Italy. So it's very member state specific. So yes, it may be critical to your sector, but that doesn't mean it's going to be exempt from work permit just because you say so. This is not up to you as individuals or companies to say, oh, don't worry, I'm a business visitor, I'm only going for one day. Oh, don't worry, my sector is critical, I don't need a work permit. Oh, don't worry, I'm this. You can think and believe all those things. What we're trying to say to you, this is immigration law, this is also national law. It is EU law, it's European law. And so these are regulations and rules that are written into employment ordinances or immigration ordinances, or statutes such as England, we have immigration acts. So it is unfortunately and frustratingly, and we do sympathise, these rules are according to the individual member states. They are not for you to try and tweak or mold into something that fits you. You have to go by what the member state says. So my starting point would be check the individual country list to see if your activity is on the business visitor list. If it's not, you probably need a work permit. If you want to see if you're exempt from a work permit, you'd probably have to hunt down the labour code. But that's where me and Tim and Make UK come in to support you. We try and find exemptions for you. If there is an exemption, then we try and help you as best as possible to find that work permit that you probably will need.
Thanks very much. Tim and Alice, another question here from Linda. We sell instruments into the EU and may have to supply training or installation in the receiving country. We are a UK company with a number of EU nationals. Will they also need permits? Specifically, a Spanish national lives and works in the UK, but we send them to the EU country to service and train companies. Thanks very much.
Yeah, I can say that. So EU citizens don't require a permission to work in the European Union. They still enjoy their rights as EU citizens. But whilst they might not require permission to work, it depends how long they're going and where they're going for. Going for a longer period of time, of course, they might end up being a resident there and have to register their residence. In fact, generally longer than 12 weeks. But in any event, you will normally find there's a notification requirement. So we spoke about the old rules before 1996 and the fact that a worker going from France to Germany had to tell the labour inspector they were sending someone. These intra-EU rules, as Alex explained earlier on, what you can't do by leaving is get a better deal. So if you're going from France to Germany, you have to tell the labour inspector and notify and comply with local labour market rules, then we can't get out of that obligation by dint of the fact that we've left the EU. So whilst our EU citizens that we employ in the UK might not need a work permit to travel or a visa to enter, whatever it's going to be, what they will need on a country by country basis is for us to tell the labour inspector we're sending someone as a third country posted worker, a third country national, and then make sure that we comply with the local labour market rules when we send them. So if you like, we're exempt from part of the process because they're EU nationals, but the other part of the process, telling the Labour Inspectorate there, those labour market rules, so Alice spoke about hours of work and pay, etc., those still need to be complied with when we're sending the worker.
Thanks very much. I'm going to transition into questions on social security, and we have one question on tax as well. Just as we sort of transition to that, one question from Joe here. If a British citizen is going to, say, Germany for a 2-day business trip, brackets meetings, do they need to apply for a visa and permit? And if so, if they do not need a visa and permit, do they still need a A1 form to cover that period?
Okay, so again, check the list of activities you as a business visitor can undertake if you go to Germany. The likelihood is that meetings and conferences will be on that list, and therefore you are a business visitor, and therefore you should not require a visa or work permit. In terms of social security, I've seen a few comments in the chat about multi-state A1 forms and whether you need one or not, and how it takes 12 weeks to receive one back. We sympathise with all those issues, and we know that HMRC are facing a huge backlog of applications because suddenly we're at the EU and everyone has come to realise they need an A1 form if they send workers abroad. Now, because it proves you pay UK NICs, it's simply a certificate that exempts you from paying local social security. If you're a business visitor, I'd say conservatively, it's less of a risk. We'd never advise not to get one. We'd always want to make sure you are fully covered in case someone requests. If you're providing a service, however, or you've got a work permit, or you're deemed to be working, it's much more important that you have an A1 form. Despite the delay in receiving a physical copy of an A1 form back, that should not be an issue. Because if you can prove that you have applied for it, you have still sent the notification onto the HMRC social security system, and it sends that notification to other European countries. So as long as you have applied for it and you can prove you've applied for it, such as you can print out the completed application form, that should suffice. And that shows that you've applied for your A1 certificate and that you're exempt. So you don't need to wait for the physical copy, essentially. If you haven't received one back, don't worry. As long as you can prove you've applied for it, that should suffice.
Thanks for that. That answered the next question, which I was going to come on in terms of if we were investigated, subsequently proving that Social Security has been paid. A couple of questions on tax. One question which refers to Appendix 5 agreement, and I believe that's Appendix 5 of the HMRC tax approach. Does that remain in place regarding taxes? And secondly, how specifically are taxes managed from a either visit or a working in a member state or EU member state perspective?
I can take that, Fergus. So tax was never part of the rules of the European Union. Alice has spoken about social security coordination. They were entirely separate. The levying of social security and tax was never a matter of EU competence. The coordination rules were important to understand on social security. So in terms of tax was always a matter of bilateral agreements between the UK and the individual member states of the European Union, as I say, on a very much a bilateral basis. Those are still as they were. So the things we've spoken about today don't specifically change whatever the tax agreement was before. So we are in the same position. What we would say on tax is this: tax is different in each EU member state. I mean, broadly, there's the 180-day rule, where if you're in that particular country for more than that period of time, then you would pay local tax. However, this is incredibly specific because, for example, we've come across many UK members that have had members of staff who have gone back to the EU during the pandemic and went back for very good reasons. And they might have stayed now for extended periods of time, but have remained upon UK payroll, paying UK tax and NICs for that specific period of time. Now, clearly, like come a point where they're no longer resident in the UK. And at the point that they register in an EU member state and say, hello, I am now resident in this member state, at that point, they're no longer a UK resident. And they're no longer a EU resident for a number of reasons. Immigration will be one, social security will be another, but tax will be a third. And at that point, you start thinking about, should they be on a local employment contract? And at that point, also, should they be paying local tax? And the answer in most cases is if you've got someone who was registered as a permanent resident in Spain, and they've been there for a period of time that might be less than 180 days, and they therefore need to go on a Spanish contract, that at that point, the Spanish authorities are going to be saying, well, this person should be paying their income tax in Spain because they've told us they're permanently resident here, and their NICs in Spain because they told us they're permanently resident here. So there are a series of consequences against people who decide to go and live in the EU on a permanent basis. And as we know, in most EU member states, you have to register your permanent residence there after 12 weeks. So don't think tax is something you can leave later in the day. But the broad answer is the tax treaties were never part of the EU or what we're talking about today. They're still good to go. However, the overlay is having left. If you've got people in the EU and they're registering now as permanent residents there, then probably it's a local employment contract and probably it's local tax as well. Alice, is there anything that I've missed or we should add?
No, but I think we're getting towards 2 o'clock now, so I think we'll leave it there on tax today for the sake of everyone attending.
Absolutely. I'll hand over to Chris in a moment just to wrap up. One last question in reference to the information we shared in terms of individuals coming to the UK. Thinking about a foreign national who is in the EU and is travelling to the UK with family for a seconded period, anticipated at this stage to be 3 years, would that be managed under a tier 2 visa in the UK? And a follow-on question in reference to the tier 2 visa, is it still a requirement to prove that you've searched the UK job market for the candidate? Has that changed?
So 2 things. If someone's going to come to the UK for 3 years, I presume they're at some point going to take up employment or work. I don't know how someone supports themselves for 3 years without getting employment. So if they were to come to this country initially for family reasons, they may be able to get some sort of derived right, some sort of spouse or family visa to stay here in the first instance. But in order to get a job, they obviously need to be sponsored, in which case they would need that tier 2 visa. I'm a little bit unsure on the meaning there because they've said 3 years, but also family reasons, and that's confused me slightly. So if someone wants to come back
sorry, Alice, that was that family is traveling with them. Sorry.
Oh, family's traveling with them. I thought someone's going to say if they see family for 3 years. I was like, that's a long time. Sorry. Well, exactly. So if the children, you need to get family visas for the migrants, they'd be attached to his application. So if the person is being sponsored for a job in the UK, he does tier 2, and from that you have family visas on the back of his employment visa, if you like. That is a big and application with lots of supporting documents and fees required. So if someone wants to come and contact us directly on that application, please do, because that's quite a big project. If that's something you as an employer are going to help him with or her with in terms of family members coming with. The last thing, Fergus, what was it? Please? So
that was in terms of whether you need to prove that you've searched the UK job market when you are offering or applying for a tier 2 visa.
Yeah, so what was previously referred to as a resident labour market test, theoretically, it's no longer a requirement. However, when an employer applies for a sponsorship license and then subsequently the certificate of sponsorship, what you need to sponsor a applicant, a migrant, you need to give some example that you have conducted a predominantly UK-based recruitment exercise first, which essentially could be a resident labour market test. It's not quite that strict, but they want some evidence you have done a fairly local recruitment exercise first, which may mean that a European national already in the UK has applied for that job. It's broad, but they just want to make sure you haven't done a beeline for a specific person in a specific country. They want you to have a fair recruitment process, which is fine.
Thanks very much. There have been some very specific questions on very specific elements of travel, particular countries and particular activities. What I will suggest is that I ask Tim and Alice to come back individually to the people who've submitted those questions. So if you've submitted those anonymously, please do contact us with the details, which Chris will give us finally, a couple of questions, Chris, which hopefully we should be able to help with. First, is there a central point where you can identify which activities are exempt from requiring work visas? And do we have any templates for the business visitor introduction letters? I think you might be able to help on that front.
Yes, thank you very much, Ferguson. And to wrap up, I think before answering that is very much to say thank you very much to Tim and Alice from IM Consultancy, and to you, Fergus, joining us down the line from Brussels. Following this session, if you would like bespoke and tailored consultancy for further support on anything that's been mentioned today, then we can help you with that. Additionally, we do also have an EU business travel guide, which you can have with a bit of an A to Z of what you need to be thinking about and doing. So you can have that to hand, which is downloadable online. And as a reminder, members can send EU and other Brexit related queries to our central inbox, which is brexit@makeuk.org. And all this information will be provided in an email along with the slides and recording following this as well. And as Fergus alludes to, we do have a EU exit hub on our website with templates and guidance, as top level guidance as well. So thank you very much for those chat comments coming in, and appreciate that feedback. So thank you very much for joining us, and all that's left to say is goodbye.
Thanks very much, Chris. Thanks, Tim and Alice.